Morning to all. So today we are going to discuss
Good
about Unit 3
morning, sir.
patterns. Morning. So in this class we are going to discuss about patterns. So 2 units we have covered already. So today we are going to start about third unit. It is about pattern. So in this all creativity already I have studied about pattern, type PR, all those things. So just a recall it will be some points will be new, familiar. Some points will be familiar and some points will be new. So before moving into the pattern system, we need to know about the history of the pattern system. Okay, Manoj, you can start now.
சார் இன்னும் கீழே வாங்க சார்.
ஓகேவா?
இல்லை சார், அந்த ஹிஸ்டரி ஆஃப் இந்தியன் பேட்டர்ன் சிஸ்டம் ஸ்டார்ட் ஆகும்ல,
அதான்
இது வந்து
ஓகே.
டைம் லைன்
ஓகே.
கீழே பிரீஃபா.
இந்த பாயிண்ட் சொல்றீங்களா?
ஆமாம் சார்.
ஓகே.
ஸ்டார்ட் பண்ணுவா சார்.
ஸ்டார்ட் பண்ணுங்க.
Before going to the topic Indian patent system, let's see what is patent. Patent is a government authority or a license conferring a right or a legal protection for a set period, especially the sole right to exclude others from making, using or selling an invention. Indian patent system. The first law in India relating to patent was the Act 6 of 1856. The purpose of this law is to encourage the discovery of new and useful products and to inspire inventors to reveal their secrets. This law was repealed by Act 9 of 1857 because it was passed without the approval of the British Crown. Then later, the new law for granting exclusive privileges was introduced in 1859 as the Act 15 of 1859. This law contained some changes to the previous law, such as granting exclusive benefits only for the useful inventions and extending the priority for period from 6 months to 12 months. And then this law is based on the United Kingdom Act of 1852. With some exceptions, which allows the applicants to apply in India and take public use or publication in India or the United Kingdom for the purpose of detecting innovations. In 1872, the Act of 1859 was combined to provide protection relating to designs, and it was renamed as an Act, the Patents and Designs Protection Act, under the Act 13 of 1872. The Act of 1872 was further amended in 1883 as Act 16 of 1883 to introduce an arrangement to protect the innovations of the inventions, which were exhibited at the Indian exhibition before submitting applications for their protections. And then the 6 months were given to submit such applications after the opening date of such exhibitions. Then the Act remained in force for about 30 years without any changes. But in the year 1883, certain changes in the patent law were made in the United Kingdom. And it was considered that those changes should be made in India also. In 1888, a law was introduced to integrate and amend law relating to innovation and design in the amendments made in the United Kingdom law. And further, Indian Patent and Design Act of 1911 replaced all the previous laws. This law brought patent management under the administration of patent control for the first time. The law was further amended in 1920 to engage a mutual agreements with the United Kingdom and other countries to gain priority. In 1930, further amendments were made, including the granting of secret patents, the granting of additional patents, the use of government inventions, the power of the regulator to adjust patent registration, and the extension of the patent period from 14 to 16 years. In 1945, an amendment was made to the filing of professional file and submission of the complete profile within 9 months. After independence, it was realized that the Indian Patent and Design Act 1911 did not fulfill its purpose. Due to significant changes in political and economic conditions of the country, seems it is desirable to enact a comprehensive patent law. Accordingly, the Government of India set up a committee in 1949, headed by Justice Dr. Bakshi Tek Chand, a retired judge of the Lahore High Court, to review the patent law in India to ensure that the patent system is optimal for the national interest. The terms of reference included survey and report on the functioning of the patent system in India, to examine the existing patent law in India and make recommendations for its improvement, and especially on the provisions relating to the prevention of abuse or misappropriate of patent rights. And then to consider whether any special restrictions should be imposed on food and drug related patents. Then recommending measures to ensure effective publicity for the patent system and the patent literature, especially with the regard to the patents obtained by Indian inventors. And then to consider the necessity and the possibility for setting up a national patent foundation in India, considering the desirable nature and regulating the business of patent agents. Then to examine the activities of patent office and the services it provides to the public, and to make appropriate recommendations for the improvement. To generally report any progress, it is appropriate to recommend that the Indian patent system be made more conducive to national thinking. The committee submitted its interim report on 4th August 1949 with recommendations to prevent the misuse of patent rights in India, and to amend and to make changes in sections 22, 23 and 23A of the Patents and Designs Act of 1911 under the United Kingdom Act. So that's all, sir.
Okay. So the committee observed that the Patents Act should contain clear indication to ensure that food and medicine and the surgical and curative devices are made available to the public at the cheapest price. So the committee recommend பண்ணது என்னன்னா, the Patent Act should contain clear indication. So food products or the medicine, surgical or the curative devices, அது வந்து public வந்து cheapest price ல கிடைக்கிற மாதிரி they have framed it. So based on the above recommendation of the committee, the 1911 Act was amended in 1950 in relation to working of inventions and compulsory license or the revocation. So other provisions were related to the endorsement of the patent with the words license of right on an application by the government, so that the controller could grant licenses for the any authorities, any organization who applies for the patent. In 1952, an amendment was made to provide compulsory license in relation to patents in respect of food and medicines, insecticide, germicide, fungicide, and a process for producing substance or any invention relating to surgical or curative devices. So the 1952 தான் என்ன பண்ணாங்க, அது ஒரு கம்பல்சரி ஆக்குனாங்க. எந்த ஒரு இது இருந்தாலும் நீ பேட்டன்ட் இருந்தால் தான் யூ கேன் கோ ஃபார் தி ப்ரொடக்ஷன், எய்தர் இன் ஃபுட் மெடிசின்ஸ் ஆர் எனி ஜெர்மிசைட் ஆர் இன்செக்டிசைட் ப்ரொடக்ஷன் or in any invention related to the surgical or the curative devices. The compulsory license was also available on the notification by the central government. So based on the recommendations of the committee, a bill was introduced in the parliament in 1953. However, the government did not press for the consideration of the bill and it was allowed to lapse. So அது வந்து ஒரு பில் பாஸ் பண்ணி கொண்டு வரணும்னு பார்த்தாங்க, பட் கவர்மெண்ட் வந்து அதில் சரியான ப்ரெஷர் கொடுக்காதனால அதை அப்படியே விட்டுட்டாங்க. In 1957, the Government of India appointed Justice N. Rajagopala Iyengar committee to examine the question of revision of the patent law and advise government accordingly. So 1957 la ஒரு justice ஒரு appoint பண்ணாங்க. He has to examine the patent. So என்ன revisions கொண்டு வரலாம் அப்படிங்கிறது கவர்மெண்ட்க்கு வந்து அட்வைஸ் கொடுக்க சொல்லி they have appointed. So the report of the committee, which comprised of two parts, was submitted in September 1959. So 57 start பண்ணி 59 தான் அவங்க வந்து ரிப்போர்ட் சப்மிட் பண்ணாங்க. The first part dealt with general aspects of patent law and second part gave detailed note on the several classes of the lapsed bills 1953. So ரெண்டு பார்ட்டா வந்து அவங்க வந்து ரிப்போர்ட் சப்மிட் பண்ணாங்க. ஃபர்ஸ்ட் பார்ட் வந்து டீல் பண்றதெல்லாம் general aspects of patent law, என்னென்னலாம் general rules and regulations according to the patent law. செகண்ட் வந்து என்னென்னலாம் அவங்க வந்து மிஸ் பண்ணிட்டாங்க, which have detailed note on several classes of lapsed bills 1953. அந்த 1953ல என்னென்னலாம் அவங்க வந்து விட்டுட்டாங்க, they didn't follow it. So அத மாதிரி they have split it into two categories. The committee recommended retention of the patent system despite its shortcomings. So this report recommended major changes in the law which form the basis on the introduction of patent bills 1965. So நிறைய changes வந்து கொண்டு வந்தாங்க இந்த report மூலமா, which was introduced in 1965. So the bill was introduced in Lok Sabha on 21st September 1965, which however lapsed. So அதுவும் என்னாச்சுன்னா அதுவும் அப்படியே ஃபாலோ பண்ணாம விட்டுட்டாங்க. In 1967, again an amended bill was introduced, which was referred to a joint parliamentary committee, and on the final recommendation of the committee, the Patent Act 1970 was passed. So வந்து ஒரு ஜெனரல் காஸ்க்காக இந்த மாதிரி கமிட்டி போட்டு என்ன பண்ணுவாங்க, they will frame a patent system. ஸோ அதை வந்து அப்போ இருக்கிற அந்த பொலிட்டிக்கல் பீரியடை பொறுத்து if it is benefited they will be moving on to the further process, or else they will not pass the bill, they will do as such, அப்படியே விட்டுருவாங்க. ஸோ the committee suggestions will be left as such. ஸோ அதை மாதிரி அவங்க கொடுத்த கமிட்டி கொடுத்த 1959 ரிப்போர்ட்டு when it was implemented 1970 தான் அதை இம்ப்ளிமெண்ட் பண்ணியிருக்காங்க. This act repealed and replaced the 1911 Act so far as the patents law was concerned. So however, the 1911 Act continued to be applicable to designs. So அது வந்து டிசைனுக்கு மட்டும் அதை வச்சிருந்தாங்க, பட் ப்ரொடக்ஷன் ஸ்டேஜஸ்க்குலாம் வரும்போது 1970 ரூலை தான் ஃபாலோ பண்ணாங்க. Most of the provisions of the 1970 Act were brought into force on 20th April 1972 with publication of the patent rules. 59ல அவங்க சஜஸ்ட் பண்ணி அதை வந்து ஃபர்தரா ப்ரொசீட் பண்ணி 65ல பில் பாஸ் பண்ணி அதையும் விட்டுட்டாங்க. Further 1970 only they have framed bill pass பண்ணி they have given final recommendation. 1972 only they are fully followed. So it was brought into force on 1972 only. So this act remained in force for about 24 years without any change till December 1994. So 24 years வந்து இந்த bill வந்து அப்படியே தான் இருந்துச்சு. There was no any change. And ordinance affecting certain changes in the act was issued on 31st December 1994, which ceased to operate after 6 months. Subsequently, another ordinance was issued in 1999. So this ordinance was subsequently replaced by the Patents Act 1999 that was brought into force 1st September 1995 and implement ஆச்சு. So the amended act provided for filing of applications for product patents in the areas of drug, pharmaceuticals and agrochemicals, and the field they can easily submit the patents. However, such applications were to be examined only after December 2004. So meanwhile, the applicants could be allowed exclusive marketing rights to sell or distribute these products in India, subject to fulfillment of certain conditions. So and the meanwhile in the act வந்து வரதுக்கு முன்னாடி they have followed the exclusive marketing rights for sell and distributing of their products in India. So அது மூலமா they can easily approach. So the second amendment to the 1970 act was made through the patents. This act came into force on 20th May 2003 with the introduction of new patent rules 2003 by replacing the earlier 1972. அந்த 72 வந்து change பண்ணி second amendment கொண்டு வந்தாங்க in 2003. The third amendment to the Patents Act 1970 was introduced through the Patents Ordinance 2004, that is which was effective on 1st January 2005. So this ordinance was later replaced by the patents on 4th April 2005, which was brought into force from May 1st 2005. இதுதான் இப்ப கரண்டா இருக்கிறது. ஓகேவா? So these are some of the years which passed through the patent and the one year what they have done. Manoj has explained, in 1856 they have framed the Patent Act, and then how it is modified, and then Patent and Designs Protection Act was framed in 1872. Then in 1883 the Protection of Invention Act was framed, and in 1888 consolidated as the Inventions and Design Act ரெண்டையும் சேர்த்து வச்சு they have created. And 1911 Indian's Patent and Design Act was framed. In 1999 on March 26 Patents Act came into force, which was effective from 1st January 1995. In 2002 the patents came into force from 20th 2003, and later on last 2005 the Patents Act 2005, which was effectively followed from 1st January 2005. So this will be a 16 mark system. What is the history of Indian patent system? So the patents போறதுக்கு முன்னாடி எந்தெந்த இயர்ல எல்லாம் எப்படிலாம் how they have framed the Indian patent system அப்படிங்கறது we need to know. So this will give you a clear idea on the patent system.